Let me change to a more law enforcement-oriented topic. I appreciate, first of all, very much your service in District Attorney Morgenthau's office. It is an office that prosecutors around the country look at with great pride and a sense of its long tradition and of the very great capability of the prosecutors who serve in it. It's a very proud office, and I'm delighted that you serve there, and I think it says a great deal about you that coming out of law school and college with the stellar academic record that you had and an entire world of opportunities open to you, you chose that rather poorly paid office. And since you've met 89 of us, I doubt you remember all of our conversations, but when you and I had the chance to meet, we compared who had the worst office as a new prosecutor, and I think you won. And so it was a very important moment for at that point, quite new lawyer to make a very significant statement about who you were and what your purpose was. And so I very much appreciate that you made that choice. And I think prosecutors like my colleague, Senator Klobuchar, and many others around this country, Senator and our chairman, Senator Leahy, made that choice over the years, and it's one that I think merits a salute. One of the things that prosecutors have to deal with all the time is search and seizure and warrants. And my question has to do with the warrant requirement under the Constitution. I see the Constitution as being changeless, timeless, and immutable. What changes is society, as you pointed out in your testimony earlier, and technology. And so new questions arise. And I'd be interested in your reaction to the difference between the experience of society and the technology of society when the founders set up the warrant requirement originally and today. When the founders set up the warrant requirement originally, when the sheriff or somebody went to seize property to bring it in as evidence for a trial or to condemn it as contraband, that was sort of the end of it. If it was evidence when it was done, it was returned and it went back. Particularly papers were returned, and that was the end of it. Then came the Xerox machine. And now the government could make copies of what they took. And it was returned, as always, just as the founders had intended. But copies were sprinkled throughout government files. Very often ones that ended up in archives buildings in dusty boxes that would have taken enormous effort to locate, but nevertheless, they remained available. And nowadays, with electronic databases and electronic search functions, matters that once would have been returned to the individual and that envelope of privacy that was opened by the warrant would have been closed again are now potentially eternally available to government, eternally searchable, and it raises some very interesting privacy questions that we will have to face in this Congress and in this Senate as we begin to take on issues, particularly of cyber security, cyber attack, cyber terrorism, and take advantage of what technology we can bring to bear in the continued struggle against terrorist extremists. So I'd be interested in your thoughts on how the Constitution, which is unchanged through all of that, what analysis you would go through to see whether the change from a quickly opening and closing privacy envelope to one that is now essentially open season forever, how would you go about analyzing that as a judge, given that the Constitution is a fixed document?
I think, as I understand your question, Senator, that there are two issues, if not more, but the two that I note as more starkly for me in your question is the one of the search and seizure and the Fourth Amendment as it applies to taking evidence from an individual and use it against him or her in a current proceeding.
Yes, which is a constant.
That's
stayed the
generally the structure. In not so long ago, the Supreme Court dealt with a technologically new situation, which was whether an individual had a right to expect a warrant to be gotten before law enforcement flew over his, or I think it was a his in that case, his home, and took readings of the thermal energy emanating from his home, and then going in to see if the person was growing marijuana.
The FLIR case.
Exactly. And in that case, the reason for that case is that apparently, I'm not an expert in marijuana growing, but apparently when you're growing marijuana, there's a certain heating lights that you need, at least that's what the case was describing, and it generates this enormous amount of heat that wouldn't generally come from a home unless you were doing something like this. And what the court did there, in an opinion by Justice Scalia, I believe it was, is it looked at the embedded questions of privacy in the home that underlied the unreasonable search and seizure. And the court there, as I mentioned, determined that acts taken in the privacy of one's home would commonly not be expected to be intruded upon unless the police secured a warrant. And to the extent that the law had generally recognized that if you worked actively to keep people out of your home, you locked your windows, you locked your doors, you didn't let people walk by and peek through, you didn't stand at your front door and show people what you were doing, that you were exhibiting your expectation of privacy. And to the extent that new technology had developed that you wouldn't expect to intrude on that privacy, then you were protected by the warrant clause. And the police had an obligation to go talk to a magistrate and explain to them what their evidence was and let the magistrate, I use the magistrate in that more global sense, it would be a judge, but in the you would let a judge decide whether there was probable cause to issue the warrant, reasonable suspicion, probable cause to issue the warrant. That's how the courts address the unreasonable, or have addressed, the Supreme Court has, the unreasonable search and seizure and balance the new technology with the expectations of privacy that are recognized in the Fourth Amendment. You asked, I thought, a separate question, which in my mind is different than the right to privacy with respect to personal information that could be otherwise available to the public as a byproduct of a criminal action or as a byproduct of your participation in some regulated activity of the government. There are situations in which if your industry is regulated, you're going to make disclosures to the government, and then the question becomes how much and what circumstances can then government make copies, put it in an electronic database, or use it in another situation. So much of that gets controlled by the issues you're saying Congress is thinking about, which is what are people's rights of privacy in their personal information? Should we, as Congress, as a matter of policy, regulate that use? The courts itself have been commanded by Congress to look at certain privacy information of individuals and guard it from public disclosure in the databases you're talking about. So we've been told, don't go using somebody's social security number and putting it in a database. That's a part of a public document, but we've been told don't do that. And there's a reason for that, because there is not only the issues of identity theft, but other harms that come to people from that situation. So that broader question, as with many, is not one that one could talk about a philosophy about. As a judge, you have to look at the situation at issue, think about what Congress has said about that in the laws, and then consider what the Constitution may or may not say on that question, depending on the nature of the claim before the court.
Your Honor, I thank you. I wish you well.
Thank you.
And I congratulate you on your appearance before this committee so far.
Thank you, sir.